Hello and welcome to St. Peter's Judicial Academy, a coaching institute for judicial services examination. Today I am going to discuss the role of the Supreme Court in a particular context. As you are well aware that our constitution makers had conceived of our Supreme Court as a court of rarity. Not all matters or cases should land up at the Supreme Court. Only genuine or deserving cases should land up at the Supreme Court for adjudication. This was the primary thinking of our constitution makers. That's why the way to approach the Supreme Court has been provided for by the Constitution to be full of difficulties. Fundamental right cases by way of Article 32 of the Constitution can directly land up at the Supreme Court. Apart from that, the majority of the cases that are heard by the Supreme Court come thereat by the way of the appellate process. So today I am going to tell you something about the appellate process, the appellate jurisdiction of the Supreme Court. The process of appeal means when a person or a party to a litigation challenges the correctness of the decision of a court before the superior court, then this process is known as appeal. So naturally, here the decision of the High Court when it challenged before the Supreme Court, this process will be called appeal. Now, can all cases decided by the High Court can land up at the Supreme Court? Is the Supreme Court having a bounden duty to entertain all the cases by way of appeal which have been decided by the High Court? The answer is no. We will have to cast a look at the constitutional provisions in order to understand the whole concept here. So I am on appellate jurisdiction of the Supreme Court. In order to appreciate the point, you will have to understand what the appellate jurisdiction of the Supreme Court is like. Of the Supreme Court. Supreme Court. By SC I mean Supreme Court. So in a threefold manner, can a decision of the High Court be challenged to the Supreme Court by way of appeal? The first one we can speak of as appeal on the basis of certificate of fitness. Certificate of fitness granted by High Court. The provisions related thereto are contained in Article 132, Article 133 and Article 134 of the Constitution. Another way by which appeal can land up at Supreme Court is compulsory appeal in certain capital cases. Capital cases means those criminal cases where death penalty is involved. The provisions related thereto is contained in Article 134 of the Constitution. And the third is appeal by the special leave granted by the Supreme Court itself. This provision is contained in Article 136 of the Constitution. So basically you have to keep in mind Article 132, 133, 134 and 136 of the Constitution in order to appreciate the overall gamut of the appellate jurisdiction of the Supreme Court. Mind you, Article 132 says that the High Court can give certificate in a matter where a substantial question of law as to the interpretation of the Constitution is involved. The High Court, maybe during the course of the hearing of the matter or after the High Court has pronounced a judgment, the High Court, be it a criminal case or a civil case, the High Court may give a certificate of fitness that this matter is fit to be heard by the Supreme Court because this matter involves a substantial question of law as to the interpretation of the Constitution. Here the Constitution itself will have to be interpreted in order to understand the point, the question in dispute. That's why constitutional interpretation related matters can be appealed at the Supreme Court on the certificate be given by the High Court. Article 133 confines itself to civil matters only. Article 133 says that in a civil matter, if the High Court finds that there is involved a substantial question of law of general importance. For example, if parties have entered into a contract and if that the terms of the contract is creating ambiguity, then in that case dispute may arise, and in a case which is being heard by High Court, which is being adjudicated upon by High Court, the High Court may say that the interpretation of the terms of this contract itself is a question of general importance, because contract among private parties also a form of law. It can, the High Court can give the certificate of fitness to such cases also, and appeal can be preferred to the Supreme Court. It was the decision of the Supreme Court in Chunilal Mehta case, which students of law study in Civil Procedure Code. So far as Article 134 of the Constitution is concerned, in any criminal case, if the High Court is of the opinion that this matter is fit to be heard by the Supreme Court, then over the decision of the High Court, an appeal may be preferred to the Supreme Court, because the High Court has given the certificate of fitness to the case. That's why the Supreme Court will be duty bound to hear an appeal over this matter. So here the point is, be it by way of Article 32 or by way of Article 133 or by way of Article 134, if the High Court has given a certificate of fitness to a particular case, the party to the litigation may approach the Supreme Court, and the Supreme Court then will be having a bounden duty to entertain the appeal and to finally decide the case. If this way is not being availed of by the litigant, then this way may remain open to them. But this method is confined to only capital cases, means a criminal case in which death punishment has been awarded by the trial court. Not all capital cases, not all death sentence related cases come under the purview of this Article 134. Here, only two-fold kind of scenario will emerge if we cast a look at the provisions of Article 134. The first scenario is in a criminal case where the trial court, generally the sessions court, you may say, if the trial court has, after considering the evidence produced before it, if the trial court comes to the conclusion that this person is not guilty, and accordingly, if the trial court acquits the person, and if the prosecution, means the state, prefers an appeal over the judgment of acquittal before the High Court, and High Court, if in its turn pronounces a punishment of a judgment of death sentence, then the party to the case, means the accused, the convicted person, has every right, compulsory right, indefeasible right to approach the Supreme Court by way of Article 134 of the Constitution. As a concept of an Article 134, in another scenario, if the High Court has withdrawn a criminal case from the Sessions Court or District Court, and the High Court heard the matter and without giving an opportunity to the District Court or Sessions Court, pronounced a death punishment, then over that death punishment, a person can directly approach the Supreme Court over the decision of the High Court by way of Article 134 as a matter of appeal. If any case doesn't fall either in this category or in this category, then the recourse open to a litigant is Article 136 of the Constitution. Mind you, majority of the business, the lion's share of the business of the Supreme Court happens to be consisted in a special leave petition, which is the subject matter of Article 136 of the Constitution. Here, the litigant, the party to the case, will have to appear before the Supreme Court, generally by way of an advocate, and the Supreme Court will conduct a brief hearing here, and if the party convinces the Supreme Court that, see, the High Court in my case has committed an error of judgment and it is for the Supreme Court to decide the case finally, therefore please allow me to have my appeal entertained. And if the Supreme Court comes to the conclusion that yes, your case deserves to be heard by the Supreme Court, then in that case the judge of the Supreme Court will say, leave granted, we are giving you permission, we will hear your appeal, we will adjudicate upon your appeal. So this is the subject matter of Article 136, popularly known as SLP, special leave petition which is presented before the Supreme Court, because Article 136 says that in any judgment, any decree, determination, order, final order, etc. passed by any court in India, the Supreme Court will have the power to grant special leave to hear the matter and decide the matter. Generally, this provision is utilized by people to challenge the decision of the High Court before the Supreme Court. And majority of the cases that arrive at the Supreme Court come only by way of Article 136 of the Constitution. Of course, by way of Article 32 of the Constitution, also fundamental right related cases also arrive in great number, but this also constitute the lion's share of the business of the Supreme Court in our country. This is the way appeal land up at the Supreme Court. These are threefold ways that you can cast a look at, and I think you have sufficiently now understood about it. Thank you.